Hi friends, good morning. Welcome to UPSC World. This is Dr. Harinath Reddy, Faculty for Indian Polity and Constitution. Today in this particular video, we will try to discuss an important concept in Indian polity and constitution, that is doctrine of pleasure. Doctrine of pleasure. So what is this doctrine of pleasure? Let us try to discuss. And related to the doctrine of pleasure, we have four important articles. Article 75, Article 164, Article 155, and Article 310 and Article 311. So doctrine of pleasure says a civil servant under the union administration or the state administration can be removed from office even without giving a notice. That is called doctrine of pleasure. Doctrine of pleasure is derived from English common law. So in England, in the United Kingdom, then we had parliamentary democracy in United Kingdom, and the head of the British nation state we called British Crown. So in United Kingdom, there was a practice that civil servants, they stay in office during the pleasure of the crown, which means the British Crown can remove any civil servant at any point of time without giving any valid reason and without giving any notice. This is called doctrine of pleasure. But you should remember that India and Britain, they differ in the system of constitution and also administration. We all know that the British constitution is an unwritten constitution. That's why in Britain, the constitution is not supreme. It is the parliament which is supreme. That's why in Britain we have parliamentary sovereignty. But in India, we had a written constitution, that too a federal constitution. So in India, the constitution is supreme. All the three organs of the government, executive, legislature and judiciary, they derive their powers from the constitution. So in India, there is constitutional democracy, there is a supremacy of the constitution. So the supremacy of the constitution is protected by the Indian Supreme Court and the High Courts. The Supreme Court of India is the final protector and interpreter of the Indian constitution. So if you take up the doctrine of pleasure in the context of India, it is not an absolute doctrine, which means in Britain, the doctrine of pleasure may be absolute, which means without giving any valid reason or even without giving a notice, a civil servant can be removed. But that is not the case in India. The reasons are, the reason for this is, we had a written constitution which is supreme, and we have the concept of rule of law. We also have the concept of constitutionalism. The philosophy of constitutionalism says that a written constitution will put limitations on the powers of the government. So all the three branches of the government will exercise only those powers which are conferred on them by the constitution. So the presence of a written constitution will act as a limitation on the powers of the government. That philosophy is called constitutional government. Then if you take doctrine of pleasure in the context of India, let us take up the first article, Article 75. Article 75 says that the Prime Minister is appointed by the President and other ministers are appointed by the President on the advice of the Prime Minister. We all know that India had parliamentary democracy. One important feature of parliamentary democracy is a dual executive. There are two kinds of executive. One is nominal executive, the other one is real executive. In India, at the union level, President forms the nominal executive. The Council of Ministers headed by Prime Minister forms the real executive. Similarly, at the state level, we have the Governor who is the nominal executive, and the Council of Ministers headed by Chief Minister is the real executive. So at the union level, after the general elections to the Lok Sabha get over, a person belonging to a political party commanding majority in the Lok Sabha will be chosen as the Prime Minister. On the advice of the Prime Minister, the other ministers are appointed by the President. If you take Article 75, Article 75 says A minister in the union government will stay in office during the pleasure of the president. This does not mean that once the president withdraws his pleasure without the advice of the prime minister, the minister has to resign. No, that is not the case. If the president wants to remove any minister, despite the doctrine of pleasure, the prime minister must advise. Only on the advice of the prime minister, the minister can be removed by the president. The president cannot do on his own. The reasons are again parliamentary democracy. In a parliamentary democracy, the president doesn't have the real power. The real powers are with the prime minister and the council of ministers. The entire administration at the union level is carried on in the name of the president, but the president doesn't decide. It is the council of ministers headed by prime minister who takes decision. That's why we say president declares national emergency, president declares state emergency, president declares financial emergency. All these are done by the president only on the advice of the council of ministers headed by prime minister. Similarly, the power to issue ordinance, the power to pardon, all these powers are exercised by the president only on the advice of the council of ministers headed by prime minister. So, in India, even though Article 75 speaks about the doctrine of pleasure, the ministers in the union government cannot be removed by the president on his own. Same is the case at the state level. 164. Article 164 says the chief minister is appointed by the governor and other ministers are appointed by the governor on the advice of the chief minister. And the ministers, they stay in office during the pleasure of the governor. So here again, a governor, if he wants to remove any minister, he can remove only on the advice of the chief minister. For example, in 2022 in Kerala, the then governor Arif Muhammad said that he has withdrawn his pleasure with respect to a minister. But this is done even without the advice of the chief minister. So such a minister doesn't need to resign because here we don't see the advice of the chief minister. That's an example. So under Article 164, even the doctrine of pleasure is not absolute. It is not unlimited because of the nature of parliamentary democracy. We have one more article, Article 155. Article 155 of the Indian Constitution says that the governor stays in office during the pleasure of the president. So the institution of governor is borrowed from the Canadian Constitution. So the governor is the constitutional head of the state government. Governors are appointed by the union government. So Article 155 says that the governor can be removed by the president without giving any valid reason. That is the doctrine of pleasure. But a case went before the Supreme Court on the appointment of the governors and the removal of the governors, especially the removal of governors. The case is called BP Singal versus Union of India. Then who is this man BP Singal? So BP Singal was a member of parliament belonging to BJP political party. So there is a practice that at the union level, when there is a change of government, the newly formed government will ask the existing governors appointed by the earlier government to resign. So the question before the Supreme Court is, if there is a change in the government at the union level, is it necessary for the governors to resign to their office? The Supreme Court said, not necessary. And the Supreme Court also said, if a governor is removed by the president on the advice of the union government by applying the doctrine of pleasure without giving a valid reason, that is invalid. So if the union government wants to remove any governor, it must give valid reasons. Without valid reasons, the governor cannot be removed merely because there is a change in the government at the union level. And the reasons given by the Supreme Court is, governor is not an agent of the union government. Governor is not an employee of the union government. Governor is the constitutional head of the state government. So to protect the dignity of the office of the governor, the Supreme Court said, doctrine of pleasure is not absolute. There are limitations on the doctrine of pleasure. What are the limitations? The supremacy of the constitution, the rule of law, philosophy of constitutionalism, they all act as limitations, which means a governor cannot be removed arbitrarily. A governor cannot be removed without valid reasons. If that is done, then there is judicial remedy available. So the Supreme Court said that it will extend power of judicial review with respect to removal of the governor by the union government without valid reason. If any governor is removed without a valid reason, the Supreme Court has the power to look into that issue and to give a judgment. So the Supreme Court told the union government, if any governor is removed without a valid reason, the Supreme Court will intervene if a petition is filed before the Supreme Court and can reinstate the governor in the office. So here again, the doctrine of pleasure is not absolute. So here absolute means even without giving valid reasons, you can't remove the governor. Then comes the next articles, Article 310 and Article 311. See, Article 310 and Article 311, they give constitutional protection to civil servants. Especially in Article 311, it was laid down. The procedural safeguards were laid down in Article 311 before removing a civil servant. For example, we have the civil servants under the union government. We have the civil servants under the state government. So theoretically it was said, the civil servants of the union government, they stay in office during the pleasure of the president. The civil servants of the state government, they stay in office during the pleasure of the governor. But Article 311 says, before a civil servant is removed, or if you want to remove the civil servant, an inquiry must be done. While conducting an inquiry, the grounds why the civil servant is being acted upon must be communicated to the civil servant. And the civil servant must be given an opportunity to defend himself. So these are the procedural safeguards. So without following these procedural safeguards, that is without an inquiry, without informing the grounds, without giving an opportunity to defend himself, if a civil servant is removed by the president and the governor, it is not valid.